Yeah, I want to thank our audience for joining us today with the Secure Justice podcast series. Today, we're going to be talking with public and criminal defense attorneys about some of the struggles, what I characterize it as an uneven playing field between the prosecutors and defense side, and more specifically, the public defender side. We're going to talk about kind of the technical expertise problems, kind of the arms race between both sides, and just see how different folks are handling it. And speak with one of our guests who helps advise these types of people and provides expertise, and just kind of identify the problems and see how people are trying to defend their clients. Brendan Woods is the first Black chief public defender in Alameda County's history, which is also where I live here in Oakland. He's currently the only Black chief public defender in the state of California. He was appointed by the board in December 2012. He's got 20 years of experience in criminal defense litigation and leads a staff of 170 and handles more than 3,000 new files monthly, which is a pretty hefty pace. He's a board member and former president of the California Public Defenders Association, and was honored with the Harvard Law School Wasserstein Public Interest Fellowship for outstanding public service. And I'm really grateful that you're here, Brendan, to share your expertise with us. Genevieve Jones-Wright was raised by her single mother in a low-income home in Southeast San Diego, where devotion to family and self-respect was cultivated. In keeping with her goal of carrying the bags of Justice Thurgood Marshall, Genevieve earned a BA in Mass Media Communications from the University of San Francisco, JD from Howard Law, and an LLM in Trial Advocacy, specializing in federal criminal defense from Cal Western. In 2018, she ran for San Diego County District Attorney, put on a very credible race. She has proudly served San Diego County as a public defender from 2006 to 2019. And she now serves as the inaugural executive director of Community Advocates for Just and Moral Governments, which is an impact litigation organization she co-founded with another Black woman attorney that works to achieve racial justice and hold government accountable to all people, especially the disenfranchised. And on March 21st, she was inducted into the San Diego County Women's Hall of Fame in recognition of her efforts. She's also a member of the Secure Justice Advisory Team. Jumana Musa is a human rights attorney and racial justice activist. She's currently the director of the Fourth Amendment Center at the National Association of Criminal Defense Lawyers. As director, Jumana oversees NACDL's initiative to build a new, more durable Fourth Amendment legal doctrine for the digital age. The Fourth Amendment Center educates the defense bar on privacy challenges in the digital age, provides a dynamic toolkit of resources to help lawyers identify opportunities to challenge government surveillance, and establishes a tactical litigation support network to assist in key cases. Jumana previously served as NACDL Senior Privacy and National Security Counsel, and she's also an advisor to Secure Justice. So again, just really want to say thank you for giving us your valuable time here and sharing some insights about the struggles you each have to deal with. Because we are an equal opportunity organization here, we're going to start with the gentleman first. Brendan, I think most people sort of grasp what a public defender does, but why does the office exist? If you kind of just, describe it in broad strokes, why your office exists. Maybe, I don't know that it's all that unique now, but it was a bit unique in that you were appointed, some are elected, and just kind of describe the staff that you manage, the different types of staffers, so, attorneys, investigators, and just kind of give us how things have been working in Alameda County with board support, the size of your budget, and how effective you think you are as an appointed public defender.
Wow. Okay, that's a lot in one question. We'll see what we can do. So I'll start off by saying thank you for having me, Brian. Looking forward to the conversation. Great to be joined by these two fantastic guests. So I'm hoping to have a really lively discussion. So the beginning part of the question, I guess, is really what does a public defender do? We represent people who are accused of crimes when they cannot afford to hire an attorney. So we represent people charged with all sorts of crimes, some things that should not even be crimes, like driving on suspended license, trespass, drunk in public, petty theft, things I don't think should be actually charged as crimes. And then we've got some people charged with more serious crimes. Could be domestic violence, robbery, rape, murder. We do all of that. And we are really an essential service because we protect people. We protect people from the weight of the government. We protect people from this massive criminal punishment system that, as we've seen, as we all know, is infused with racism. And so we are, in some ways, on the front lines fighting against mass incarceration. People are accused of crimes every day. Some people have committed crimes, some people have not. And there is a strong need for people to represent them and to fight for them. So that's what we do. I want to clarify one real common misconception about public defenders that's out there. Number one, public defenders are lawyers, okay? We have law degrees. We go to law school. We have graduated from some of the best law schools in the nation. And I really want to be clear about that. So public defenders are, in so many ways, amazing lawyers, and they are completely badass. We are good at what we do. And a lot of people jump into this work to fight for people, to fight for our clients, to fight against mass incarceration, to fight against systemic racism, to fight against police, to fight against judges, to fight against this criminal legal system that is destroying our communities. And that's why a lot of us got involved in this work. A lot of us who do this work have seen how the system has impacted our community, how it's impacted our family members, and we want to be able to protect against that. And I think over the last 10 years, public defense has started to reimagine itself and gone down a different road with regards to providing real holistic defense and being real forceful advocates in multiple arenas. So I see the job really as being a war against poverty, and we're doing so much more. So for example, in our office, we've expanded and we're doing things like hiring social workers to address the root cause of why people come into the system and to provide them with services and to get them some sort of services in lieu of incarceration. We have a pretty robust clean slate unit to clean up people's records after they've been convicted of a crime. And we're now doing some civil legal remedies there. We've hired partners for justice advocates to help with housing, employment, licensing. So we're really expanding out. We've hired an immigration unit. We're the first public defender's office in California to represent our clients in immigration court. And immigration court is a whole different sort of horror and pain that's almost unimaginable. And the fact that there is no right to counsel in immigration removal proceedings is absolutely insane. So those are some of the things we do as public defenders. Has it been a struggle and battle to get that put in place here in Alameda County? Yes. I mean, it is a struggle, but that's what we do. I think you asked one more part of that question, which was about being elected and not being elected. And that's a great question. So, okay, because if you think about so at times, do I like to be elected? Absolutely. I mean, absolutely. I would love that independence that comes with being elected. But at the same time, we think about the amount of counties just in California, for example, that voted for Trump last election. I think it was about 23 out of the 58. Having an elected public defender in that county would scare me. I'm not sure I trust the general electorate to understand what we do completely or respect what we do. There are times when our duties will come in conflict with the public. So for example, imagine being an elected public defender in Orange County, where they're very pro-death penalty, and your job is to fight against that. There could be some real conflict and tensions. I think that the public defender really should have the power of an elected, the independence of an elected from the seat of an appointed. And that's the way it should really work. So I know I've kind of rambled on there, and we want to hear from our other guests, but once again, thank you for having me, and happy to follow up with any of that stuff I just said.
Yeah, no, that was perfect, Brennan. I appreciate that. I appreciate the honesty, especially in that last part, or being that candid in the last part. I'm not your client, and that was already just inspiring to hear what you said, is like that, how hard people in your office fight for the disenfranchised. I'm local but I'm obviously an outsider. But when I watch you guys, when I see you in the media, and I don't know how you sleep, I see you all over. You're always going to schools to educate people. You're training the next generation. It's seriously a great body of work. I hope you live to be 200 years old and keep doing this, because it's really inspiring.
Thanks. I'm one of those little rated people.
I will share a funny story. When I first met you, I was still pretty new as an activist. I mean, it'd been a couple of years. It was 2016. Alameda County was acquiring a stingray. And, first we tried to block it. And it was just clear there was no support. And for those that don't know what a stingray is, a cell site simulator. It's used to geolocate cell phones. And it mimics a cell phone tower. And there was just no board appetite for telling the district attorney no. And so we pivoted to try to make a strong use policy. I actually negotiated on the floor at the very last minute the first annual report, to my knowledge, in the world, and certainly in the country, in the United States. So, we got a little extra transparency out of it. But this was the first time I'd ever met Brendan face to face. He was in the audience. I got introduced to him right when the DA walked up. And the tension in the room was amazing. I mean, I'm like, did I miss something? Is there a war? I mean, there was a war. It's a philosophical battle between the prosecutors and the defense side. And it was just, I was just like, oh my goodness, like I felt like I should put, Kevlar body armor on or something. But like just the two of you standing within 2 feet of each other was an incident. Now contrast that with the next guest we're going to speak with, Genevieve. When I first went down to San Diego, we were advocating for a surveillance ordinance and a privacy commission. We walked into the police department and she got hugged. Now, I've never seen that happen. And I got a little nervous. I'm like, is she maybe not what she says she is? Like, why are the police hugging a public defender? Nope, she went in, she spoke truth to power, got in their face, told them what they needed to hear. And then they hugged her on the way out. I've never seen this before. I don't understand. So Genevieve, tell us a little bit, San Diego County, 8th largest city in the country. I'm assuming, and I did look at the county website, you probably had a much larger budget, a larger staff. Kind of describe how you saw the inside of San Diego County. Did you have sufficient resources to do your job, to provide an adequate defense? What was your average caseload like?
So the public defender's office here is right about 400 staff members, which is less than half of the DA's office. And the DA's office, just to put a point on it, has close to 1,000 employees. Now in the county of San Diego, we are in budget season, and the budget that's being proposed for the public defenders, which has to be, of course, finalized and approved, is just over $100 million. And this is the very first time we've seen that mark with the public defender's budget, whereas the district attorney's budget consistently hovers north of $200 million. And so the budget that we're seeing being proposed at the Board of Supervisors for 2021, 2022 for the DA's office is right around $237 million. So as you can see, it's more than double the public defender's budget. The public defender's office here in San Diego, I always said when I was a public defender, which I count myself as a public defender for life, that we're very blessed to be in California because we've obviously seen and heard the horror stories that take place in other states where they're severely under-resourced and funded. We always have experts on an array of topics at our disposal, and we were able to retain what we needed. We have hardworking investigators in our unit at our disposal for our defense. Our public defender's office has great units like our Fresh Start unit and our defense transition units that provide behavioral health support, for example. Just what Brendan was talking about with his unit, the Fresh Start program helps to give people a clean slate, if you will, when there are convictions that need to be expunged, taking a look at convictions that should be reviewed. But we continue to be understaffed in the public defender's office, even with these great units that are doing great things. And while we hear things from our public defender, like we've never had to tell our attorneys no about something that they wanted to spend money on for defense, we recognize that when we ask for money, it is limited by cuts and because of things like the pandemic. And so public defenders work extremely hard. San Diego is not an exception. Brendan talked to us about how hard we lawyers work as public defenders. And it was not uncommon for me to have a caseload close to 100 cases at times. I worked in various courthouses around San Diego County. So in our Chula Vista or our South Bay courthouse, also in East County, I worked in our downtown courthouse. And it was always amazing to see that no matter where I was in the county, that some things are just the same as it relates to injustices and the work that public defenders have to do. I really want to echo what Brendan talked about, because one thing that I love to talk to people about is that we are the upholders of the Constitution. We are the guardians of the Constitution. We safeguard the Constitution. We are written into the Constitution, right? And that's something that people don't really think about or reflect on. But public defenders are critical to actually having justice in our criminal legal system. So I'm going to end there, but I will also say that one thing that has always struck me as completely, probably ridiculous, I would describe it as, is that taxpayers pay for a lobbyist in the district attorney's office here who gets paid as a full-time employee to lobby against bills that we support as taxpayers. As we are moving into a direction where we're saying we need to be more humane, we need to stop trying to incarcerate our way out of our societal ills. We need to have better responses than law enforcement showing up when there's a call about a homelessness issue or a substance abuse issue or a mental health crisis. We actually have a district attorney's office here that uses our taxpayer money to pay for a full-time lobbyist that goes to Sacramento and opposes the bills that we want to see on the books. And I think that that is insane. And I also think that if the DAs have a lobbyist, why can't the public defender have a lobbyist when we know there are several bills right now in Sacramento that are directly impacting our clients, people who are indigent, who cannot afford attorneys, and we only get to hear the voice of these district attorney associations or even the full-time staffer lobbyists to go and tell our state representatives that we actually don't need those changes. So that's all I got for right now.
I appreciate that. Brendan, to come back to you for a second, because kind of the nexus for all four of us is the use of surveillance technology and just having the technical expertise to defend people. A while back, you graciously met with my board member, Steve, and some grad students from UC Berkeley's iSchool, the information school. They went around and surveyed public defenders to just see, the types of resources they had, data needs, expertise. Do you, I watch agendas, I see the budget. It looks like you have a decent budget here in Alameda County, but I forwarded a couple articles to you folks. I mean, do you have people on your staff that can, get into a Cellbrite debate with a prosecutor's expert witness or a Stingray? Do they understand all the GPS and the geolocation apps and data? Do you have people that you can go to trial with that understand these things?
Yeah, that's a great question. We do have some people on staff who are very well versed and very knowledgeable, but it's no substitute for an actual expert in the field. We do spend money on experts for those type of cases. I think we're better situated in a lot of offices. We've spent quite a bit of money, but we don't have anywhere near the resources needed to put into place investigations or experts for all of our cases. So, we of course prioritize the felonies, which are more serious. I'd love to have it done for the misdemeanors, but we can't do it in all the cases. We just can't based on the volume. So yeah, we do have people on staff, but as far as what we need, not even close.
And how a question just kind of popped into my head, and Genevieve, you could jump in too if you need. But if you got 100 cases and criminal matters generally are accelerated or get priority, or certainly just go much faster, or they have a shorter life cycle than most civil litigation. Do you have time to do a deep dive if you need to? If it's a felony case and you've got cell tower dump and you get this massive, document dump from a DA, do you even have time to go through it, or do you just kind of make your best guess?
So I say you have an obligation to do that. If you're having to spend nights on end looking at that cell phone tower data, that's what you do. If you need more time, then you ask for it. But you have an obligation to look at that data. There was a DA here, I will not say what unit they were in, but they were notorious for dumping things like that on you at the very last minute in hopes that you either wouldn't go through it or that you give them the continuance that they wanted, right? And so sometimes you're kind of striking that balance, but you always want to make sure that you're prepared. And cell tower data, specifically for me, was the game changer in a lot of my cases. And being able to consult with experts on what the data even meant, and also me having a familiarity with the data itself, resulted in acquittals. Because sometimes what the prosecutors say, the data represents or shows, it's not even true. And so for me, I believe and I know that you have an absolute obligation to look through those documents. And even if you do have a severely overcrowded caseload, you've got to put in the work for every single client. There's just no excuse. You have got to do the work because someone's life and liberty is on the line, and it's your job.
Can I just piggyback a little bit, Brian? So I think, there's definitely a need for that expertise to be held in-house in public defender offices. I think New York Legal Aid Society has their own sort of forensic unit within their office, which is what's needed in almost every urban office. And just for an example, like I've been trying to get funding added to my budget for a Cellbrite machine, just one machine, and then also to have someone trained how to use it. It's been denied for the last 3 years. So, but the thing is, though, we end up paying for experts to do the work. So I think as we move forward in public defense and we want to try to improve it, each office, especially those in urban areas, should have some sort of forensic unit within their office. I think it's necessary. There was one more point that's going to be made, and I can't remember what it was. I want to get back to it. Sorry.
Well, let me jump in right there because the sheriff just got a bunch of Cellbrites in addition to $300 million for his jail. Your request got denied?
So
let's the same board.
Let's talk about budgets, and because that's part of the conversation here. You can't talk about public defense and where we're at without talking about budgets. So there usually is a process in the counties where budgets go through a county administrator and they get to the board. So there's all these kind of blocking points for money to be approved. One thing we have to think about and that people don't realize, as was mentioned, we are enshrined in the Constitution, okay? There is no constitutional right to prosecution, okay? There is no constitutional right to jail people. There is a Sixth Amendment right to counsel, okay? And it's not funded properly anywhere in the nation. I'm gonna go on record and say anywhere in the nation. Throughout the state of California, almost every PD's office is outfunded 2-to-1 on the dollar by DA versus public defender, okay? So I'll give you an example. I'll break down in our county, just our county right now. We're in the middle of budget process. The DA's proposed budget right now is $93 million, okay? $93 million. The public defender is $45 million, okay? That's what it's probably gonna land up. We're gonna have half the budget of the DA's office. They, I think, outnumber us by about 160 staff, 160. My staff is about 170. And when we pull back and think about how it all works and what really happens, every DA's office in the state generally gets their case already prepared and handed to them on a silver platter because all the work's been done by the police department already. Okay? They're getting everything done and prepared already. And if we break down and look at the budgets of police departments in Alameda County, you've got Oakland PD, OPD, 300 million, Fremont PD, about 100 million, Hayward's about 80 million. So we have all this money spent on police, incarceration, prosecution, and control, and very little spent on the one that's guaranteed by the Constitution, on the one that's built to end mass incarceration and to fight against putting people in cages. So it comes down to priorities. It comes down to having people, the public and electeds, figure out where they want to spend their money and what are their priorities. I'm sorry, I went on my little rant there.
No, that was great. And I just want our audience to understand why we're really focusing on this uneven playing field. Every, I'll just call it type of law that I've looked at, the presence of counsel changes the results. Immigration, landlord, tenant, civil, where the middle class can't even really afford an attorney anymore here in America. People that have attorneys put on better defenses. They get better results. It's across the board in every type of law. And so it is exactly what Brendan just said, is we are prioritizing incarceration over essentially due process, over a fair fight. Jumana, NACDL, and more specifically, your Fourth Amendment Center, which you direct, you provide guidance to the defense bar. If you can describe for us what that entails, the collaborative nature of your work across the country as you meet with attorneys on Fourth Amendment and surveillance tech matters. I think that's how I first met you. You were out here in San Francisco doing a survey of predictive analytics and stingrays. Mm-hmm. How do you just go about approaching people and providing guidance to them?
Well, first I have to say, you already noted in my introduction, when I started at NACDL, there was no center. I was there as Privacy and National Security Counsel. I was meant to sort of do our internal work on these issues, do some policy advocacy. And what became clear to me really quickly is, particularly if you're talking about congressional advocacy, the process is slow. I won't tell you that Congress totally gets it when it comes to these tech issues. And, although they're moving slow and incrementally, the one thing that became clear to me is that every time they try to swap something away, they trade away the rights of the accused, right, in criminal cases. And so, but the other thing that we saw is courts were starting to get it, right? When you go and talk to them about technology and the Fourth Amendment or all the other pieces of it. And so it became clear that in order to do this work effectively, in order to ensure that people's rights are protected, right, when the power of the state is bearing down on them, what we needed was an educated defense bar. And it's not to say that, defense lawyers are on it, they just don't know what they're talking about. The reality is what my colleagues have already talked about, right? If you're a defense lawyer, you really are at the front line of defending the Constitution. And at the same time, you may have 100 cases, right? And in order to keep up with all this information, it's a full-time job without any cases. And so we really wanted to be able to help bridge that gap. I know for any of these technologies, you brought up cell site simulators earlier, or stingrays, it's hard to find out they're using them, right? And so by the time defense lawyers know that this is in play, they've been using them for 6, 8, 10 years sometimes, right? Because it's not often disclosed. And so what we do and why we exist is to be able to do the trainings and create the materials that people can just grab and say, okay, and now I have a sense of this. I know what flags to look for in my case. I know if they say these things in the warrant that I should think about, a stingray or a geofence warrant or some of these other kind of texts. We have sample briefs and motions that people can access, so we can help file. And we also do direct consultation, and we have litigators on staff that help people litigate key cases, right? And we do all that because our thought on this is very much, both obviously in support of the defense bar, which is what we do all day, every day, but also in order to get better legal doctrine. Because right now you have a constitution that was written that could not conceive of the world we live in, right? And the way we amass data, the way data moves, the way it can tell about everything a person's life entails. And so that's sort of the crux of why we do what we do. We are, I think, 3 years in now, or just about 3 years in to building this up. And, we find that we're starting to get traction. We're finding out information a lot faster than we ever would have by going to court on these things, by subpoenaing Google or other parties than we would have if we tried to do some type of public records request. And the more people we train, the more traction we see. And so that's sort of the short answer of why we do what we do. I'd be happy to talk about any one of those things individually.
In the Domain Awareness Center back in 2014, which is when I first walked into City Hall. And during the Domain Awareness Center in 2014, kind of my big sister showing me the ropes was Linda Lai. Now the Honorable Linda Lai, she's been appointed to the bench, Contra Costa Superior. She was a senior staff attorney at the ACLU. And she bumped into Daniel Rigmaiden, who, as a pro per, sort of discovered stingrays had been used to track him. And she wrote this really great guide for the defense bar, coaching basically attorneys like how to ask questions in discovery. And so I imagine, Jumana, you do some stuff like that. Is that what you mean? Like you were telling people like how to identify red flags?
Yeah. So, we have a few things like that. We have a whole series of webinars that you can find on our webpage. It's sort of through various topics, but we did work with the ACLU and EFF on a guide on government hacking. We have a guide on compelled decryption, a primer, which is when they try to force you to unlock your phone, either biometrically or with your code, or other ways they try to break in. But, I think the other thing that we are focused on, and as we're talking about resources and imbalanced resources, right, in terms of DA's budgets being far larger than defender budgets, and then you add in the police budgets and all the other things, there's also an imbalance in the technology, right? So Brendan was talking about like he's trying to get a Cellbrite machine, and maybe someday they give him the money and he can get that machine and send somebody to be trained on the machine. What he can't get is the version of the machine that they only sell to law enforcement, and that exists, right? There's no access to that. So it doesn't matter how much money they give him, he can't have it. We also know with things like body camera tech, again, either one of my colleagues will tell you, if you get 10, 12, 25 hours of body camera footage, it is on you to go through that footage to make sure there's nothing in that body camera footage that's going to tell a different story than what shows up in the evidence or the reports, right? It's your obligation. But what we also know is that there is tech that gets given to prosecutors where they can just sort of zip through and say, show me everywhere where there's a red t-shirt, show me everywhere where there's a car driving by, show me everywhere. So they don't have to sort of watch second by second to find whatever that key piece of information you're looking for is, right? And this imbalance happens, again, throughout. And that's before you even get to the question of, can you access the technology? Can you test the technology? Can you validate it? Can you get behind what makes it work, to even see if it does what it says it does? And, spoiler alert, the answer is no, you can't. Because they claim trade secrets. They claim that it cannot be they have non-disclosure agreements. There's sort of lists upon lists of the reasons they don't give that up. And so you end up in a situation where the tools you would have in any other kind of court case, right, where you can bring a fire door challenge, where you essentially challenging the science, validate the science, show we can confront what it says it does, test it, and then find out if it really does that. There's no opportunity because you get shut down on trade secrets ground where the company says, well, this is proprietary, we can't share it. And so, we've used it and we validated it. We're telling you it's fine, and just work with that. And, there's many stories as to why that's not fine, that we could get into. But this is it sort of complicates the imbalance. It's beyond just budgets or having the expertise to know how these things work, but they just don't make the information available to the defense, no matter how much expertise, how much they have in their budget, how many machines they get. There's a whole pocket of that information that just never transfers.
So I forwarded to you all a couple stories, and I'm going to put them up here in our post-production. In Denmark, it was shown that somebody was wrongfully convicted by cell phone tower data locations. And as a result, Denmark is now looking back all the way through 2012 to see if other mistakes were made. Also recently, the FBI hair follicle story came out. And I'm just going to read a quick little snippet here of the 28 examiners with the FBI's laboratory. 26 overstated forensic matches in ways that favored prosecutors in more than 95% of the 268 trials reviewed so far. And Jumana, that's according to your Oregon Innocence Project. Are there other, forensic horror stories we should be aware of right now?
Well, I can tell you one thing. One of the technologies they use to test mixed DNA samples, they had gone through and said, yes, we validated it and this is how it works. And they'd done a number of cases on it, later to find out that they'd actually made tweaks after that validation. And so the validation that they were relying on and saying, this is why we know it works in court, was not actually validating the way the system was working when it tested the materials, right? But again, these are the things that don't come out until later. And so I think we see it when we get access. And I think, again, we have the bigger problem of the number of times you don't get access. And it's being, sort of argued in a number of cases, trying to get access to what's behind face recognition technology, trying to get access behind what's, in the mixed DNA methods, trying to get access to what does it mean when Google says, well, we did when they get a geofence warrant. And I'd like to explain what that is. It's the difference between, normally if you watch a cop show on TV, they go and they say, we think this is the suspect, and maybe they'll get their credit card records, their cell phone records, or some kind of record. This is the opposite. They know something happened, right? There was a thing, there was a robbery, there was whatever the crime is that happened, but they have no idea who they're looking at. They don't have a suspect, not one, not even an inkling of a suspect. So instead they go to a company like Google and say, hey, Google, tell us everybody who connected in this geographic area, this 150 meters during this 1 or 2 hour time frame, every phone that connected. And our litigators have been working on these cases. And as they've dug into the case, they found a number of things. Like step one, there's 3 steps to how they do this warrant. Step number one is that Google checks all of their users, searches all of their users to see who is connected in this geographic area. And by their own words, that is numerous tens of millions of people. So they go through their numerous tens of millions of people to find out that maybe, 150 people connected. Here's the thing that we found, in terms of the back and forth. Usually the process goes, so then they go back to the police, they say, we have this 15 people or 150 people, whatever it is. And the police says, well, we would like more information on this subset of it, right? On 7 people. This is anonymized data. I use that term loosely because you can de-anonymize this kind of data pretty easily. So step 2, they say, okay, here's some more anonymized data on these 7 people. And they say, well, we think that our person is in one of these 3. Let us know who these 3 people are. And so that's essentially the process. But the thing we found out in the course of litigation is, are those people even really in that 150 meters? Good question. Maybe. And I say maybe because it's not that precise. Like, this is not your actual location on the map. And if anyone has ever done a ride sharing app or something like that, and you punch in, this is where I'm going, and then it has you a half a block away or on the other side of the street, it's because it's not saying this is your exact location. What it's saying is, when other people have asked for a ride from, and they've pinged off the same cell towers as you or the same Wi-Fi or whatever, they were in this spot. So we can guess you're in this spot. And so the accuracy is around 68% that you may or may not be in the circle, which means the circle is not so circular, right? It's very messy. And so there's so there's myriad problems when you start to get into what does all this mean? And how do you find it out? And then what can you access? This has been a long process just to get this information, right? But these warrants have been out there for a long time, these types of warrants. The process that got developed was not something that's judicially sanctioned, where they say, well, if you're going to access this huge trove of information, these are the protections in place. Best we can tell, and I don't know if there's another process that nobody's hipped us to, but best we can tell, this was what Google developed when they said, okay, you want this information, we're going to go back and forth. But anybody who's interested in the Fourth Amendment should be real clear on, other than the fact they start with searching their tens of millions of users, then there's a step 2 and a step 3 where nobody ever goes back to a court. Nobody ever gets a new warrant, right? That's just a negotiation between the tech company and the police. And so all of that to say is, you're now in this sort of brave new world where you don't even need a suspect, right? You just need data to try and triangulate people. And there's so much data that is becoming easier and easier. So, we're in a place where you can have all the lawyers in the world, you can have all the resources in the world, but the tech is moving so fast, they're selling it to the police so quickly that, getting back to your point, how do we know? It took years to figure out the issues about hair microscopy. And my colleague, Vanessa Antone, was critical in that, in terms of sort of uncovering all of that. And now they're working on, going back and looking at people who are convicted based on that evidence. But because this is proliferating so quickly, I think that we need to try to be on the front end of reining it in because being on the back end of disentangling it is going to be difficult, messy, and people are going to lose years of their life.
That just pretty much ruined my day. That is some terrifying stuff, which gets to that Denmark story about the wrongful conviction. And I need to find a link to this other story. The guy, I don't believe there's a conviction, but he had to spend a ton of money. He was suspected of homicide of an elderly woman. His Garmin bike little tracker and a combination of cell phone tower data and like his Fitbit all sort of had him in this location sort of at the right time. And so they just focused all their efforts on him, and he had to go through great expense and hire technical experts to defend himself. And it's just terrifying that you get trapped in this web. Something you brought up, though, I want to ask Genevieve and Brendan, because I just watched the iSchool students that I was referring to earlier. They did their capstone presentation to their advisors. And when they did the survey of public defenders, they got a lot of sassy, interesting feedback. But there was a common theme that corporations will bend over backwards to give the prosecutors what they want, almost just voluntary. Whereas public defenders, you send a subpoena and they're like, fight for it. And Brendan, Genevieve, is that sort of your experience as well? You just have to chase a lot harder, or do you generally get cooperation from tech folks when you subpoena them?
We have not had any cooperation almost with anybody in anything. So yes, that's absolutely our what occurs here, is that there's really a fight to get data from tech companies. And we have some attorneys who love that fight and are really good at it, but it shouldn't be a fight that has to happen.
And Jen, is that your experience? And then to both, do we need a statutory change, a penalty for non-cooperation? I mean, what's the solution to make this more fair?
That's absolutely been my experience. I don't know what we need. I say all of the above. And I really think that this illustrates the problem with the public safety narrative. The idea that somehow prosecutors are serving justice, so we're going to help them, whereas defense attorneys are helping to get the bad guys out or off. And that is the real issue. It's how we talk about what public safety really means, what criminal justice really means, what a criminal justice system really looks like. And we have to include corporations in this conversation because they're vital to it. They hold a lot of evidence and withhold a lot of evidence from defense attorneys, and they will absolutely bend over backwards, to use your words, to give it to a law enforcement agency at the detriment of our clients because we can't prepare. And it shouldn't be a fight. This is yet another layer of work that defense attorneys have to do when we should just be doing the other work that we have to do in order to prepare and to defend and do whatever we need to do on behalf of our clients. Fighting with corporations for things that we should be entitled to should not be one of those things.
Jumana, I want to come back to you for a second to kind of help me set up a couple of additional questions. I think when I decided to invite you onto my advisory team, because you were in a rather feisty mode, we were at an NYU law policing project.
Yeah, that's my all the time mode.
Okay, well, good. Then I guessed correctly. You were somebody I wanted to associate with. But you coined this term, or at least to me, it seemed like you coined it. It was the first time I ever heard it. It was a roundtable about facial recognition technology, but you were broadly talking about a lot of surveillance technologies, and what you said was the scientific veneer of infallibility. That, well, a computer told me this, so A, it can't be racist, and B, it must be true. Can you kind of expand upon that and where that's becoming a problem, in this space that we're all in?
Sure. And I love that you remember that, because I don't remember that I said that, but I'm really impressed with myself. That's a good one. I should write it down and use that again. I think it's exactly what you were talking about with the question of hair microscopy. And we've seen it with burn patterns and, things that get brought to court as scientific fact, right? And I think because many of us are not scientists, just not just lawyers, obviously, but I mean, just the general public, we're not scientists. That's usually sort of reserved for that small bastion of like really smart people that get all this technical stuff. But sciencey stuff is exact, right? It's not like the law, which is, it depends. What do the cases say, and how do you argue facts with the case, and all this mushiness? Like science is supposed to be very like A plus B equals C, and that's it, right? There's no other way to answer the question. And so I think because of sort of that understanding, plus then you get shows like CSI, right, where everybody watches, and as already what Genevieve was saying, that like you got the good guy law enforcement prosecutors, and then they have all the technical evidence, so they keep the bad defender from getting the person off on the horrible thing that they did, right? So not only the narrative of who's the good guy and who's the bad guy, but there's always that science that tells you, without beyond a shadow of a doubt, that this thing happened. And so it is easy for people to buy into science as an answer, as it's technical. And so therefore, if the thing said it was, it must have been. To be fair, defense lawyers will absolutely use it, right? And that's what's been used for a lot of exoneration. So it's not that science writ large is problematic in defense, but what's really problematic with these developing technologies is they're being held out as super scientifically valid, which, like I said, without the ability to be validated by outside parties. And in addition, without people fully understanding what they are doing, right? What is this technology doing? And I mean, judges don't always understand what they're signing off on. Like when they say sign off on a Stingray, back when they thought they were getting requests like it was a pen register, which is like the to and from number you call, like this number called that number and this number called that number, which is not what a Stingray does. It's much more invasive. But again, having the lack of foundation of what the technology in can be a problem, within the judiciary. Now you want to talk about juries and getting them to understand some of these things. Again, with face recognition, it seems super sciencey, right? Where it's taking a picture and scanning it and saying, okay, this is this picture. But it's taken me a lot of digging to understand, not really. Like it's not even looking picture versus picture. It's just sort of matching data points to data points and then saying, well, here's a pool of photos that look like they could be that person, right? It's really a suggestion. It's not a definitive answer. But again, this isn't necessarily how it gets shown or how it gets processed by people. And that's before you get into the detail of what was the training data and what did they put in there to sort of figure out how you match this or that. And can it even recognize, and this has been part of the problem with face recognition, people with darker skin or people who are older or people or women or, all these other categories of folks that it doesn't recognize properly. But it is, the technology in so many areas has moved so fast and it's fancy enough, right, that it seems like it can do, like if anyone watched Minority Report back in the day, it seemed like this super futuristic thing, but it's essentially what they're dealing in now when you talk about automated decision-making systems and other pieces of tech. And I think the real critical part that gets lost is that technology is not race neutral. It just isn't, right? I mean, it has, again, because it's a computer, right? Computers can't be racist. They don't have biases, but they're programmed by people. And if you look at largely who's making the tech, who's developing the tech, it is largely white men. And that's just fact, right? This isn't a shocking statement. That is who is in the industry. And you could see it from basic things. Like I know my kids play video games. I think anyone who has kids, especially this past year, they're playing some video games. And my kids are biracial, right? They have an Arab mom, they have a black dad. They do not have straight hair. They have hair that is black hair. And they went to make their little characters on their video game. It turns out and I looked at it, I was like, well, how come you guys are both bald or you had baseball hats on? And the answer was there was actually no black hair choice on the video game. You couldn't choose hair. They couldn't choose hair that looked like theirs. And if you paid money, you could choose one hairstyle, and that was dreadlocks. And so I don't think that this was a conscious choice where whoever was programming was like, I'm not putting in any of these, they gave all kinds of hairstyles, right? And when they thought of one that maybe could be different, it was dreadlocks. And that was their only option. And so, I mean, I think this is just the kind of indication of it, not necessarily even a conscious bias that filters in, but an unconscious bias that says we're going to use older white men as our training data, right? Not women, not people with different skin tones, or we're going to, program this in a way where we're taking everything neutral. We're just going to go by zip code and past interactions with police and, all these other questions of things that are basically proxies for race, but they're not, tagged as race. And so this is how you end up in a space where you have technology that seems real high end and exact, that is filtering and in many ways tech washing the same bias, the same problems that you have in the system writ large. But because it appears, like, what did I say? It has the scientific veneer of infallibility, right? Like on the TV shows, like in the movies, people will buy into it in a way that they wouldn't if you have somebody on the stand that you can actually, break them down and question them and tear apart their testimony. And so that's the problem we're getting to with these technologies.
I think most of you are aware that I had a little incident. We've since settled our lawsuit, but based on a single license plate alert and no other information, my brother and I had 4 guns pointed at us, courtesy of the Contra Costa Sheriff's deputies. And I just discovered, Genevieve, you had an incident like that. Sounds pretty darn similar. So can you share a little bit? I know this isn't really a public defender question, although I think you were a PD at that time, but tell us what happened with your interaction with license plate readers and cops.
Yeah, so it's a little murky because, to be completely honest with you, the PR spin machine was already in motion. And what I heard as I was being commanded at gunpoint and with canines barking at me was to take the keys out of my ignition. Note, I have keyless start, and to place my keys on the roof because I was in a stolen vehicle. Now, that is not the information that the officers got, apparently. What they got was, after running my license plate, which was always a little bit concerning because I was the only Black person in a sea of white people leaving the beach area in San Diego, that they run my plates and not anyone else's. But what came back to them supposedly was that my license plate didn't belong to my car. Not that my car was stolen, not that license plates were stolen, but that there wasn't a match. And so upon getting out of my car after hearing these commands, I immediately told the officer, please check in my glove compartment, look at my registration. The license plates belong to my car and this car belongs to me. They did not do that. They could have extinguished the entire reason for the stop within seconds. They decided that they would handcuff me, that they would put me in the back of a patrol car. There were a number of cars and officers that were called to the scene. And finally, after being in the back of the patrol car and handcuffed, after several minutes, I would say close to 30 minutes, they finally looked into the glove compartment, saw my registration, saw that my license plates were indeed my license plates and that the car belonged to me. But this was after they put a canine in my trunk. This was after they put a canine in my car. This idea around, and it's not an idea, racial profiling, it happens. And that's what I was a victim of. And it wasn't the first time that I was racially profiled in San Diego. And in San Diego, we have a lot of data and studies originating well before the 2016 independent study that the city paid for, where San Diego State University analyzed traffic data and police data to determine that Blacks and Latinos are stopped at a higher rate than their white counterparts and also searched at a higher rate than their white counterparts. We now have the Campaign Zero study, which also confirmed that this happens. And I kind of want to tie this to the conversation that we just had around technology, because what I was itching to say was that these tools that are being used are shaped by things like criminal history that are shaped by racial disparities in policing. And the one thing that I want to constantly emphasize is that things don't start in the courts where disparities happen. It starts on beats, it starts in neighborhoods, on our streets. It starts with policing, and it starts with racial bias in policing, where people are profiled because of the color of their skin. And when you have algorithms that are created by humans, you have a built-in bias, you have built-in race-conscious bias. And using these tools that are commonly used by the courts to determine future criminality, right? These risk assessment scores, that's what makes it problematic. Because when you live in a community where you're more policed, where you are stopped more than your white counterparts, you are searched at higher rates than your white counterparts, but also less likely to be found with contraband, by the way. I think that should also be said. as it relates to results. Not only are they searching us at a higher level, they actually should be searching white drivers more than they search Black and brown drivers, because in comparison, white drivers are actually more likely to have contraband, but they're not being searched. So I digress. We really have to get a handle on how we talk about policing and the way it shows up in our courtrooms, even through things like risk assessment scores that will formulaically flag Black defendants as future criminals more likely to, and that's going to be a wrong label. And that's at twice the rate as white defendants, whereas white defendants are mislabeled as lower risk than Black defendants. And we've seen this through studies that ProPublica has done, but also with the data that comes out of states like Mississippi and other states that use these technologies. And these are the things that I really love to talk about. And so I was just so happy to hear Jumana talk about this. And Brian, I know this is in your wheelhouse, but we really have to start to have these conversations on a broader scale, because there are so many things that cast a wide net and bring so many of us as people of color into the criminal and justice system that we really have to address when we're talking about addressing disparities and disparate outcomes.
Can I add to that? Because I mean, amen. But I think, right now, for anybody who's sort of doing advocacy around the criminal legal system, a lot of the work is on unwinding the damage of the war on drugs and mass incarceration. But for us, the way we're approaching this is where we are with this uptick in tech that is being rolled out fast and furious without any checks and balances in a country where there's absolutely no law regulating your data, none. Right? It is the Wild West out there when it comes to people's data. Companies are collecting it massively. Third-party companies are shoveling up troves of data collected by other companies and then interrogating it and classifying you and all these kinds of things. So you've got no protections in terms of consumer protections on your data. And you've got all this tech being rolled into the criminal legal system. And as you pointed out, being coded with things that are, like I said, proxies for race. What we're ending up with is really an era now of mass criminalization, right? Where it's not just sort of the decisions on who's in, who's out, are you a threat, are you not a threat? I mean, that happens early on, that happens to kids in school, right? We're getting put into gang databases who are being flagged as, on things like Chicago at one point had a strategic subjects list as someone who's more likely to either be the perpetrator or the victim of gun violence, right? And with these sort of talk about all these good reasons they're doing it, but the reality is they are classifying people, they are gathering data, they are keeping the data, they're putting them on databases that make them more at risk of being investigated, prosecuted, and put in jail, right? And so you cannot try on one end to unwind what we've seen as problematic, right? Which is over-criminalization, criminalizing everything, and then adding sentencing enhancements and all of that. We've seen where that got us. No, we're good, right? But if we don't address what they're doing with this technology, we're repeating that cycle. We're just catching people in it sooner, right? Because it's not even about just the police encounter on the street, is where the cops are being sent to go patrol and what they're being told before they even open their mouths to talk to the person who's on the street, right? In terms of the way they're gathering this data. So it's very much sort of a brave new world, but that's why we are really intent on trying to address the technology now. I know just yesterday, I believe, and there was a massive campaign from grassroots groups to push Amazon to not sell their face recognition tech to law enforcement. They had said they were going to put a moratorium on it for a year. They've now extended that indefinitely. I mean, that's work happening on the ground. I'm not saying that's any CDL. It was a massive grassroots movement, but that's the place where we need people to be, to understand the science isn't as sciencey as you think. And you don't have to be a scientist to get what's wrong with it.
Genevieve, very, sorry you went through that. It was terrifying for me. Nobody checked my ID, nobody talked to us. I've got the privilege of skin color. I was terrified, but I kind of thought, I was going to survive. So, I'm really sorry that you went through that. And that kind of leads into my next question. Brendan, Black man, Black father, I assume you've had the talk with your children. Would it make a difference if we had a Black DA? There's kind of a movement. I mean, there's definitely a progressive DA movement where we're trying to get more progressive candidates to run, but would a Black DA make a difference to really changing the culture or is it the institution itself that needs to be revamped?
That's a great question. So I will say that I am all in favor of recruiting Black people to be in positions of power. I think that can have a difference, but it comes down to the person probably more than anything else. So if I think of the biggest example we have in California of a Black DA who had the opportunity and maybe was even labeled as progressive at some point in time was Jackie Lacey. Okay. And looking at her record as a prosecutor, I would take so many other prosecutors who were white, whatever. I didn't care about race, but you think about what she did during her 8 years, when as prosecutor of the largest DA's office in the country, in a very, very blue state, in a blue county, 22 out of 23 people she sent to death row during her tenure were people of color. Okay. Since 2012, during her tenure, she sent more people to death row than I believe was Georgia, Louisiana, Mississippi, Tennessee, and Virginia combined. Okay. So based on that and those stats, I don't give a damn in some ways. Okay. We look at California, and the most progressive DAs right now that we have are Chesa and Gascon. They're not Black, but they're doing some amazing stuff. You know, I'm not one to really tout the progressive DA movement. I've got some issues with it, I do. But having people in those positions who care about people, who care about humanity, who care about systemic racism is critically important. And I don't really care in some senses what race you are, as long as you get the damn job done. And if I have 1 second on the progressive prosecutor thing, it's really important to have people doing the right thing in those positions, but it says something when we are rewarding people that's progressive just for doing their damn job, right? I mean, it's what they should have been doing the whole time. I mean, we shouldn't be placing people on a pedestal for not prosecuting marijuana cases or not charging low-level misdemeanors. That should be what they've been doing the whole damn time, okay? And the fact that they are being persecuted for doing this is absolutely insane. I mean, that there's recall efforts for people who were just doing the right thing. It goes back to our conversation about law enforcement, what it means, what criminal quote unquote justice means, and how it whole thing needs to be revamped. I've been saying a lot that this cannot be reformed. It can't be reformed. It has to be torn down and rebuilt from top to bottom, bottom to top.
Jen, you wanted to jump in.
Yes, I got to. Let me tell you, I'm over here in the amen corner, the hallelujah choir. This is what Brendan does to me. Absolutely. I have nothing to add. I just want to say, yes, sir. Amen, brother. Here's the thing. I don't care what the color of your skin is, because, and I make this example, and I may get into some trouble right now because I'm the president of the Black Bar Association here in San Diego. But the DA right now just put in a number 2. For the very first time, they're touting that we have the first African-American who's second in command at the DA's office. Well, let me tell you something. I wouldn't praise the first Black person to be the grand dragon of the KKK, right? So what are you doing in that position? If you are upholding white supremacist institutions, that's nothing to praise about. I don't care about the first Black this or that. If you are willing to help perpetuate a system that is oppressive, a system that thrives on white supremacy. And so, yes, I completely agree with Brendan that we have to really, really expand the conversation from reform to dismantling these institutions. When my students tell me, I'm an adjunct professor, when they tell me that the system is broken, I challenge them on that, because we have enough evidence in our Constitution to know that it's not a broken system. It's a system that is operating the way that it was intended to operate. So how do we rebuild a system? And the key is to completely tear it down and rebuild it, not using the master's tools. But that's all I got.
I think you just gave me the tweet we're going to use to broadcast, promote this. That was great. I know we're running out of time. I want to just sort of respond to a couple things, or just kind of lift up Oakland on something we did. You know, the concerns Jen and Jumana both raised at the end about past police interactions, that data being used to feed, risk assessments. That's exactly why Oakland, just 3 days ahead of New Orleans, was the first city to ban the use of predictive analytics. Our stop data is exactly what Genevieve described. It shows white folks have higher rates of contraband, less arrests. Blacks are detained at disproportionate numbers, and yet they don't have anything on them, no contraband. I don't know, Brendan, if you saw recently, Berkeley's data came out is actually even worse than Oakland's. And Oakland's been under federal monitoring now. We're in our 18th year. And, during the course of our conversation at the Privacy Commission, I'm like, sure, I'll let you use this technology. Go fix everything else first. If we're based on a system of racist policing practices, there's no way that we can let you use these technologies. It's just going to, it's that feedback loop. It just cements these problems into place and pretends to legitimize them because, oh, it's a computer, it can't be racist, but it's based on racist collected data. And that's been a big problem. I just want to just close, thank all three of you for being here. This is definitely one of the more enjoyable conversations I've had. I hope we can continue this conversation again. There's a whole lot more I want to talk about, just, digital monitoring of probationers, the sort of digital incarceration trend that's going on. There's a lot of things that I hope maybe we can do a part 2 down the road. But you guys spoke fire. You were amazing. And I just really appreciate the expertise. Thank you guys for participating.